Brethren have raised some very important questions, and you also realize the significance of these questions. We need not tell very experienced counsel standing before us. There are undoubtedly constitutional questions involved, and we need two kinds of assistance. One on the constitutional plane.
में हुई थी वहां से फिर ये हाई कोर्ट आ गई थी and there was a two-member bench of the high court headed by Mr. Justice KMA Samdani at that time who was seized of the matter on private complaint. अच्छा जब ये private complaint at one end चल रही थी तो नीचे जब ट्रायल स्टार्ट हुआ तो ट्रायल जो है वो हाई कोर्ट ने अंडर 526 अपने पास मंगवा लिया तो उस वक्त चीफ जस्टिस ने 13 सितंबर 1977 को ये ऑर्डर किया कि ये अब यहाँ चलेगा. सो वो ट्रायल तो उधर चला फिर वो प्राइवेट कंप्लेंट का पता नहीं लगा कि क्या हुआ उस टू मेंबर बेंच.
ट्रायल के साथ मर्ज नहीं हुई एफआईआर एंड प्राइवेट कंप्लेंट.
I have not seen it from the record.
नई केस के तहत तो फिर कंप्लेंट पे पहले कार्रवाई होनी चाहिए
जी. वो फिर वो रिकॉर्ड में नहीं नजर आ रहा कि
किसी ने ऑब्जेक्शन किया डिफेंस साइड से, किसी ने कहा कि वो कंप्लेंट भी पड़ी है इसको इकट्ठा रखे और उसको लगाएं पहले.
सर जब एविडेंस पढ़ेंगे तो पता चल जाएगा उसमें ऑब्जेक्शंस दिए गए हैं.
Mr. Attorney General,
read the evidence.
Farooq Naik sir, just to get the course right of this matter, I think the first question you have to answer is the maintainability of this review, and we'll come to the facts later of the reference. So you'll have to assist us that under 186, what's the question of law? Because a decision has been given by the Supreme Court, review has also been dismissed. Now, that is the end of the matter. On what principle? आपके जो grounds अभी तक आपने दिखाए हमें, they are talking about as if you are vesting us. Your argument is as if Article 186 vests another appellate jurisdiction to review the existing judgments of this court, and all the grounds that so far that we've seen are factual relating to the judgment itself. Now the question is, there is finality attached to the decisions of the court, right or wrong. There could be bad decisions passed by the court, they're final. So the question is, what is the question of law that is for us to give our opinion on when the matter has already been settled by the Supreme Court? So if there is a question, you'll have to articulate. Is it outside the judgment, or because the factual position of the judgment cannot be touched? That's been decided. Review dismissed. That's the end of the matter. And we have no jurisdiction to review second review or look at it through a second appeal. There is no such concept under 186. So 186 at best would be a question of law which you will have to articulate before us. It cannot arise out of the factual position of the judgment because that's settled. We can't look at the facts. You'll have to go outside if at all there is any argument, which I don't see in the ground so far. So that's a difficult question. We already have decisions of this court and of the jurisdiction from India also, which say we can't touch a judgment given by this court and look at it at a policy level. If this happens, then tomorrow there could be references, we keep opening all our judgments. So you'll have to really articulate a point. Under what basis do we go into 186, which I would imagine is a difficult one. So please concentrate on the maintainability and the constitutional question. How do we open this matter, if at all? How?
Your Lordship is right. See, under Article 186 of the Constitution, 3 tests have to be met before an opinion is given. It should be of public importance and question of law is involved. And if these 2 tests are met, then the 3rd test is with regard to giving an opinion by this Honorable Court.
Mr. Naik, the 186 says that the question of law is for the court to determine.
Yes.
The question of public importance is for the President to determine. That's for the President. We don't. That's not our problem. Our problem is what's the question of law? Is the question of law saying this judgment is wrong? Is that a question of law? That is not, to my mind, frankly, speaking for myself, does not constitute a question of law. The judgment is wrong. There has to be more than that, and you'll have to come up with that argument as to what it is. Because if this is the policy, then tomorrow the President can start sending references, start revisiting all the judgments that we've ever given. That will not be a correct way of going about it, and you understand that.
I understand what
so we'll have to come up with, you'll have to come up with something to tell us. What is that novel argument that shows that 186 can be invoked in this matter? So please, this is not easy.
And one thing I would like to add, Attorney General,
to decide anything, we have to give the opinion.
Yes, my Lord.
Therefore, what has been said till now, that relates to the determination of something by this court. That is not the scope.
It's actually a very serious question. Because when you say it's a question of law, the law has been decided in the judgment. Whatever judgment Supreme Court gives is the law of the land. So this is the law. So what's the question of law? So you can't say this judgment is wrong. It's not a question of law. There has to be something else.
Basically, the entire reference is based on the interview of the judge.
Naseem
Hussain Shah. That can be a question of law because it was a factual aspect that has been interviewed by some TV reporter after his retirement. And whether this can be a question of law because the entire reference, the crux of the reference is based on that interview. You have to address that, whether it will be converted into a question of law, whatever he has said. Because there were 3 dissenting judges also. He could have been a dissenting judge of that.
My lord.
What was the pressure on him? Why is...
Mr. Knight, let me take you to the real, what you think your question is. Your question is that during a deviation period or any dictatorship, the judiciary is not independent and they don't decide independently. That's a big assumption that you're throwing at us. You're saying that in any martial law, the judiciary is not independent. Hence, this is not a fair trial. You'll have to build a very strong case that how do you break that assumption that the judiciary is independent even during martial law period? And if it's not, what's the evidence? And if it's not, then what is the consequence? But that's a big assumption you're challenging. You're saying that in any deviation period, the judiciary is not independent. That's a big assumption to touch.
I will try to persuade your lordship on this point.
Can I just, before we get into... we're not...
Other things will follow.
Okay, now I think my brethren have raised some very important questions, and you also realize the significance of these questions. We need not tell very experienced counsel standing before us. There are undoubtedly constitutional questions involved, and we need 2 kinds of assistance. One on the constitutional plane, and the other, if you overcome the constitutional plane questions, then expertise on the criminal side. So I've noted that there were a number of constitutional experts who are no longer in this world. So I think we need to maybe appoint a few experts on both the matters as constitutional as well as the criminal. We'll first hear the constitutional experts, and then, depending on where we stand, proceed to hear the criminal experts. So I observe a notable constitutional lawyer, Mr. Raza Rabbani. Mr. Raza Rabbani, would you be willing to be appointed as amicus? But we want thorough, we'll extract every ounce from you. It may not be a pleasure by the end of it.
But we need to demonstrate should be independent.
एक second. Sorry, why do you keep interrupting?
My case.
But we are appointing an amicus. You have an objection to amicus?
That's what he has raised.
I hope
independent होना चाहिए. He's asking that.
Should be independent.
If you can propose an amicus, we'll hear your suggestion. Do you have a suggestion on constitutional thing? Mr. Kasuri, now we are asking you. Do you have a named constitutional expert?
asking this question at random. Let me think it over.
Think. Okay, by all means think. Okay, now I don't know. We would also like, and the expertise on this bench, my colleague on the right is of course expert in criminal law, but it may help us to have another former judge. I don't know if does anyone have an objection to Justice Manzoor Malik being appointed as amicus? We leave it up to his lordship whether he wants to submit something in writing, whether he's agreeable to it or not. If anyone has any objection, please let us know, because I think there is considerable criminal expertise in the person of Justice Manzoor Malik. Would anyone have any objection?
I think it's a good choice, my lord. It's a good
I don't
choice.
have any objection.
It's a good choice.
If anyone else you can propose, the other day there was a very competent lawyer from Lahore, Mr. Salman Safdar. Do you have any objection? The two names have been given by my colleagues as well. Mr. Javed Khan, who was a former Attorney General, and Khwaja Haris, who was then the Advocate General, who has been in this case as well. So, thoughts on that? Anyone has any objections, so we can then have these names?
I think we should get some legal academic also. I think it's high time that we get some academics.
We may add to them when we're later on if some colleague comes up with another name. So, but if anyone has any objection to these names, subject to their agreeing.
If your lordship would give, like Mr. Kasuri has sought some time, if your lordship can give me a few days, I'll think about it and give the name.
Do you have any objection to these names?
Sir, Khalid Javed Khan is a good lawyer, but I've got my doubts his practice on the criminal side.
No, constitutional.
Constitution is okay.
Constitution.
Constitution is okay.
Like I said, there are two aspects to the case.
Constitution is okay. Good.
So, like you know, Mr. Raza Rabbani, I hope he doesn't mind my saying so. I will consider him a constitutional expert, maybe not a criminal expert. And there is Mr. Shahadat Awan here, who I will not consider. It will be the other way around.
Sir, Khalid Javed Khan is okay as far as the constitution is concerned.
There are a couple of other names also. Mr. Salahuddin Ahmed could be one of them. Mr. Faisal Siddiqui could be another. There could be the son of Justice Fakhruddin Ibrahim, Mr. Zahid Ibrahim. So we want amicus also by, as far as possible, by consent. So let it not be that we have a particular persuasion. We don't want that to come across at all. But we don't want long-winded speeches to be made at the bar. We would expect the amicus to submit things in writing. We will formulate what we think needs consideration so they can think over them, submit them in writing, and we can call upon them if required or if they want to add something to it. But we must have something in writing from them.
So right now I can give consent to two names. One is Mr. Justice Retired Manzoor Malik and Mr. Khalid Javed Khan. As for the other names are concerned, I'll have to consult my client, my lord.
Salahuddin and
the client is sitting very far away.
Both will assist properly.
No. We don't want to. You please address us. Ji.
सर ये दो नाम तो ठीक हैं
ठीक है तो ऐसे भी नाम होना चाहिए जो आपको नहीं पसंद है
वो आपकी मर्जी है that I'll leave it to your lordship then
otherwise the complainant may object
आप वैसे ऐसे नाम देख लें जिससे आप इस रेफरेंस से फ्यूचर में कुछ अचीव करना चाहते हैं बाकी प्राइम मिनिस्टर्स को सेव करना चाहते हैं ऐसे नाम हो ताकि हमें गाइड करें
my learned brother has mentioned the name of an academic Mr. Yasir Qureshi.
He's at Oxford. He teaches constitutions.
No objection, my lord.
So we won't ask him to come. We can request for
send an
thing through email.
Academic is important to have an academic also. It's very important.
So, I need to bring that culture into our
flair. It will bring a flair to it.
By the way, Kazuri Sahab, if you want to submit a name, you okay. And if anyone else, you can give us a name. Yes, fine. So, अच्छा एक तो ये हो गई बात. The other thing is that there are other family members of the late Zulfikar Ali Bhutto. They may want to engage counsel. We'll leave it open for them if they want to do so or not.
My lord, only his, yes, there are, but as far as these...
Because primarily we're concerned with the decision affecting their lives as well.
We will ask them and let you know, my lord.
We will just pass an order and that order becomes public so they can find out themselves.
Okay.
But we won't hear any person in person. We will only hear through counsel because these are all highly technical, legal, constitutional issues before us. So we won't grant any personal hearing. The only exception is, and we would request him, Mr. Kasuri Sahab wants to engage a counsel, he can do so. He can represent himself. He's a senior counsel as it is. So if this is all right, then what date would you like to propose?
My lord, after winter recess?
Yes, it has to be after winter recess.
Which winter? This winter, I think.
This winter, not the others.
The only one question, I just remembered. When was the last date of hearing in this
My
case?
lord, it was 17th January 2012.
17?
January 2012.
No, I have an order sheet of 12th November 2012.
My lord, 12th? What?
November.
Sorry, 12th November, yes. Not
What happened then?
So with that background, they should come up in 2034.
yes. 12th November.
Ek second, can you read that order of the 12th November?
Reference number 1. A request for adjournment is made on behalf of Chaudhry Etizaz Ahsan, Senior ASC, as he's gone to Karachi to attend the funeral ceremony